I have Daniel Cranmer.
And his attorney is gonna come in and be a Zoom judge.
Okay, cause number 20-34861 is now called the State of Texas versus Daniel Joseph Cranmer. That's you, sir.
Yes, sir.
And I have a motion filed by John Floyd and Chris Show, attorneys of record for the defendant. And you are Mr. Show.
That is correct, Judge.
And where's Mr. Floyd today?
Mr. Floyd was in court in Harris County. He is on his way back to the office, but he had court in Harris County.
All right, there's a motion to withdraw that's filed. Please summarize it for me, sir. Thank you.
Thank you, Judge. Primarily, there was a legal services contract in which a trial fee became due upon the case being set for trial. That happened back in 2021. Numerous reminders were sent to Mr. Cranmer along with phone calls. It ended up being that he would not respond to our emails or our phone calls, which created some conflict. And the couple of times that he did respond, he said that he had the money, he just wasn't going to pay it. And that began to create resentment between the firm and him. And we're at the point now where we've never filed a motion to withdraw for failure to pay fees, but we've finally done it after my 13 years of working with Mr. Floyd, because the relationship is irrevocably damaged because we cannot rely on his word, and it creates problems for us taking anything that he has said at face value, Judge.
All right. Generally, the court is sympathetic toward issues on pay, but this one, in all cases, are circumstance based. This is a case that was indicted, going on, well, it's 3.5 years old, over three and a half, going on 4 years. The date of the event in the indictment is 2010. That's 14 years ago. This is continuous sexual abuse of a child. Of a complainant in a serious case like this has to be thought of as well. Are we saying we want to grant the motion, have the defendant start over in finding an attorney, and someone's going to talk to the complainant and say, I know this is 14 years old, you're going to wait another 4 or 5 years?
We understand the...
No. When were y'all hired? What was the date you were hired, please?
In approximately 2020.
And now, when is the trial? When is the trial date?
April. I may.
In 2 weeks?
2 weeks, yes, sir. April 15th.
So you filed it on April 1st, as we are coming up to a case that's almost 4 years old, on the eve of trial on a continuous sexual abuse of a child. This is brought up to the court on something that, according to you, has been a systemic problem for years.
We understand how it looks, Judge. I personally would have...
What it is. It's what it is. It's not what it looks like. It's what it is, isn't it? What's wrong with my analysis on that?
We have never had to file a motion to withdraw for failure to pay fees. The problem is that Mr. Cranmer has finally pushed our final buttons, and we have had to file this because we no longer can rely on being able to communicate with him or to have any sort of good working relationship with him, Judge. We regret having to file it, but we had to file it. And we do understand that it is a delay. in the case. However, we do not feel that there is any more of a working attorney-client relationship at this point. And our concern is that if, depending on what happens at trial, if this came back at a writ, it becomes a problem for everybody as well because of the antagonism between us and Mr. Cranmer.
I think that's something you're gonna have to deal with. I just find this inappropriate at the timing of this for something that you know has been bubbling under for a while on the eve of a serious, one of the most serious types of allegations in the penal code, continuous sexual abuse of a child. To tell me that y'all need to be released because of a problem that's been going on for years with your client, that's not timely, sir.
I understand, Judge. We tried to give him every possibility to communicate with us and to meet his obligations on the contract. And he,
How old was the child victim at the time of this? Younger than 14?
Yes, sir.
Okay, in a case like this as well. In determining whether relief is to be given in a case involving a sexual assault of a child younger than 17 years of age, such as in this, the court can consider the impact on the victim of the continuous of a continuance or a release at the eve of trial after years of representing a defendant. And the reason that you're giving me is something that is no different from the reason that existed years ago. And on the eve of a major trial like this, the court finds that it's not appropriate. It's not fair for all parties. And it certainly could have been dealt with long ago so that on the eve of trial, we don't start up from a cold start on a major case, because any lawyer rehired in this, it's going to take a while to prepare. Maybe we all know that. And we're talking now about a case that's going on, an event that occurred almost 15 years previously. And we're heading up toward 4 years from the indictment, and several years your firm has been representing the defendant.
Judge, I will say for the record that Mr. Floyd has been in touch with me on a continuous basis concerning this ever since I've been on this case. And I know he's spoken to the previous attorney numerous times just to let the court know they have been working on the case.
What does that mean?
I just that this is just one of those that they've always been honorable with me. And
I'm not saying he's not.
No, and I
It's just-
honestly believe it's just.
Well, you're representing the state. What do you have to say about this? You got
I
a
want to go to
victim.
trial, Judge.
Okay.
We've got a victim that needs to go to
You
trial.
disagree with a continuance. You want to move forward.
Yes, sir. I understand their position, but I've got a complaining witness that's been waiting for numerous years to get this taken care of, and we're going to take care of it.
All right, the courts have ruled on motions to withdraw in the past, and I'm citing a recent case, Reed versus State, where the attorney similarly requested to withdraw for payment reasons. And And the trial court granted the motion to withdraw. Then the Court of Appeals ruled that the trial court abused its discretion in granting the trial attorney's motion to withdraw. And the court's decision on a motion to withdraw is an abuse of discretion review standard. And we could go, it's a never-ending list of what factors can be used. There's no real set litmus test. But the disruption that may result in a trial proceeding as a result of the attorney's withdrawal is an issue. But here it says the attorney's role, if any, in creating the need to withdraw. You've told me for years y'all have been having a payment problem, but that was something y'all decided to address and stay with and deal with. And then on the eve of the trial, again, when's the date set for this trial?
15th, Judge, in a week and a half.
April, in a week and a half. On a major trial like this, which generally takes a week or so to trial. I can't say that the attorneys didn't help in creating this problem that I have to deal with right now that's in my lap. What, Mr. Cranmer?
Yes, sir.
Well, you know, you've had an issue paying your attorney.
I offered the best I can offer at this point, which would be to use a combination of credit cards at the very last minute, just because it's going to really destroy my financial situation. Unless I'm looking at being on the other side as one way or the other.
Well, you can imagine how your financial distress
It's bad.
is not something the court sympathizes with. That's your problem. Like, it's everybody's problem. Finance is everybody's problems. But once again, this thing has been around for almost 4 years, this serious matter. And you've had other things you think are more important to pay for? So, no, I hate to get involved in a financial thing, but what are you able to do to pay these people to help you?
What I've outlined,
Sir? Sir,
what I've outlined.
how much are we talking about?
On top of the almost 30,000 I've already paid, they are requesting 20,000 for the trial.
Well, that's, I don't want to know the specifics. How much are you able to pay?
At this moment, if I had to pay right this moment, I might have.
In your
1,000.
master plan you have about your credit card
No.
situation, how are you
I
gonna,
should be able to pay it off. By that,
by when?
by the week of trial. That's what I'm working on.
Oh, okay. Okay, he says, did you hear that, Mr. Show?
I did, Judge, and I apologize, but this is just another example of how we can't rely on his statements because he's been telling us all along that he can pay it.
Well, he's not gonna dun me, which is called dunning. That's a term used when you try to fake people out about the money. You're gonna be held accountable, and we're gonna see where you are in a couple of weeks. And I expect your obligations to be satisfied based upon what you told me. We're gonna have a hearing on this. We're gonna have to postpone this case for a couple of weeks. But in 2 weeks, you're gonna either be good for your word or you're gonna be good for your word in jail. I'll hold you in contempt because I'll rely on what you have to say. And we're not gonna start from a cold start and have an attorney have to get ready for months and months on a case this old. They put in the time, and I expect, and it's all fairness, you have an obligation. But I'm finding that by dunning them, you are also dunning the court and misleading the court on your obligations, which you will pay for if I find you don't honor them. So you take care of this, because I don't want something to start over again on attorneys. You work with them. They're good lawyers, but don't lie about things. They need to know where they stand as well. But this case it's too old.
Your Honor,
This needs to be
I have
moved
not- I
forward.
have not tried to lie. My situation has changed, obviously.
Everybody's got financial problems. Welcome to the planet Earth. We all have financial problems, but each of us have to figure them out. Every one of us have issues.
Judge, just to be clear, when we come back on the 15th, we're not for trial, it's a hearing to see where we're at. Is that
Yes.
correct? Okay.
That's what I'm going to do.
Judge, with Mr. Floyd's office with some potential dates, because scheduling with Mr. Floyd's office has been somewhat difficult. It's been.
He takes care of his position. Y'all are going to have to make special arrangements to get here for this trial because I'm not going to wait months. It's going to be just a few weeks, sir. Chris, do you understand?
Yes, Judge, sorry.
You got your marching orders.
Yes,
Take
sir.
care of your obligations. We're going to see you back on April 15th. And I want to hear some good news. And then that case will be specially set. This is terrible. Anything else to add?
No, Judge.
Okay, I'll see everybody back on the 15th. Get a resetting, sir.
Thank you, Judge. May I be excused?
Yes, sir. Yes, sir. Thank you.
Thank you.